So we now move ahead on our next topic, which is assessment and reassessment provisions. And to take this forward, we have Mr. Amit Rana, partner PwC India. He has over 20 years of experience in working of tax and regulatory matters of Indian and foreign companies, including inbound and outbound planning, M&A, international tax, including issues for digital companies, dispute management, and advocacy. Good evening, sir. Welcome on board.
Thank you. Thank you very much.
So, sir, you can take this forward by sharing your PPT and I'll share link.
Ridhima, can you see?
Yes, sir, it is visible. You can start the slideshow. That would be better. Yeah, perfect. Sir.
Okay. Yeah. Okay, so I will cover the amendments that have been introduced in the finance bill under these reassessment provisions. I think assessment largely faceless is not part of what I'm going to say, but mainly it is relatable to reassessment provisions under 147, 48, 49, and some consequential amendments that have been introduced in search provisions and block assessment. That's broadly what the coverage is. This is the way I've organized this. So give you some background on these amendments. Then we'll talk a little bit about the most anticipated topic, which was there in reassessment, which was on the notices that had been issued under 148 after March 31, 2021, up to June 30th. So the validity of those notices, and we'll talk about that a little bit. Then we will get into this theme of expansion of the entire provisions under reassessment and all the amendments that have been brought in, which are expansionary in nature. And then we'll cover the rest of the amendments in these four categories. There are some which are merely simplification, some which are addressing some inadvertent drafting errors. Then there are some which are aligning with the whole search scheme under 132. And then some clarification on existing provisions. That's how the whole presentation is organized. So the first one, there were new reassessment provisions that were introduced last year, we would all remember, where the finance minister on the floor of the house said that there is too much uncertainty that taxpayers have because of the long limitation period of 6 + 1, 7 years. And therefore, she said, I'm reducing that to 3 years, 3 + 1, 4 years. And there was a whole new scheme that was brought into the law. And now there have been some, I think, drafting issues, and then some changes that have been made relatable to those reassessment provisions is what we will be covering today. And I already spoke about the categories in which we talk about those. So the first, as I said, is the most awaited, or at least people who are worried that this will come about. So we would remember that when the new scheme of reassessment came last year in the budget, that was effective from April 1, 2021. And it brought in that 3-year limit for reassessment and a new procedure to be followed. And under that new procedure, unlike in the erstwhile procedure where following the Supreme Court decision in GK and Drive Shaft, there was a certain way in which the tax officer had to give reasons to believe, etc., etc. So this whole process was laid out, the new process. But the tax office, before the new regime kicked in, issued notices to people for the past because they wanted to, go under the old procedure and cover the past period. So the timeline for that was extended under that Taxation and Other Law Amendment Act that was passed, where they extended the timeline for issue of such notices first from March 31st to April 30th, and then from April 30th to June 30th. And there were a host of notices that were issued. We understand that almost 130,000 notices were issued. And then taxpayers went to court challenging those notices, saying that under the Finance Act of 2021, a new procedure has been laid out, and you can't simply issue notices under the old procedure, and therefore all of those notices are non-est. So courts have looked at this issue, and multiple courts, including the Delhi High Court, have given rulings which basically uphold the view of the taxpayer that these notices that were issued post April 1, 2021 pertaining to the prior period under the old law cannot be issued because the Parliament brought in a new law effective April 1, and the Taxation and Other Law Amendment Act cannot override. So that's an administrative act. It cannot override the act of Parliament. So that ratio was used, and courts have struck down those, multiple high courts. And now the matter is pending in Supreme Court. So government has gone to Supreme Court because the fate of that entire 1 lakh odd notices depends on that. So people were expecting, anticipating, or at least worrying that the government will bring in some retroactive law to remedy that situation. So that was one of the most awaited things in this budget from a reassessment provisions perspective. But the good news is that no such amendment has been introduced. So as things stand today, unless the Supreme Court upholds the validity of those notices, all those reassessments potentially can get quashed. And therefore, you fall under the new law. So that's the first thing which I want to update this group. Then moving on, this is the first part of the actual amendments that have happened. So these are the expansionary provisions that have been introduced under 147, 48, 49. And I'll just talk about that and how I believe these are expansionary. So the earlier provision, I'll just recount those. Just sorry, just give me a second. So the existing provision, as I said, was introduced last year in 2021, under which a new limitation period of 3 years was brought in, and subject to certain conditions, it could go up to 10 years. The two main conditions were that the income that was sought to be taxed or which had escaped assessment was more than 50 lakhs, and the income was represented in the form of an asset, and the tax officer had evidence of this. So these were the conditions under which the 3-year period could go up to 10 years. And then the other element of the new procedure was that the assessing officer was required to have information based on which he was going to issue the notice. So those were the new procedures. Now, what has happened now? First change that has been made is the reference to rupees 50 lakh, which was there per year earlier. That reference to 50 lakhs for that year has been removed. That the highlighted text in the first bullet has been removed. Thereafter, the second change that has happened is the expansion in the scope. So, as I said earlier, the AO was required to have information on which he was to issue the notice. Earlier, there was certain categories under which the information was classified. So, if he got an audit objection, a final audit objection, that was one category where he could, initiate 148. The other category was if their internal system flagged certain, based on risk-based procedures, flagged certain taxpayers. So based on this information, they could initiate a 148. Now that list has been expanded. First is instead of saying final, the category of final audits, it's saying any audit objections can be used or can be considered as information. Second is information which is received from a foreign jurisdiction under a exchange of information. Third is any information made available to the AO from the faceless collection scheme. So under 135A, there is a new faceless collection scheme which has been introduced. It will get notified hopefully shortly. But if any information is collected by the assessing officer under the faceless collection scheme, that's also a basis for him reopening. And the last is a tribunal or court order. So any order from any court can also be used to initiate a 148. So this is the first expansion that has happened. Second is, the 3-year to 10-year period, and this is very important. The 3 to 10-year period can happen. Earlier, as I said, it was if the income was more than 50 lakhs and represented in the form of asset. So that 50 lakh has been, that anyway has been diluted. And the other one, they've added these additional categories where they're saying that that income can also be represented in the form of expenditure in respect of a transaction, event, or occasion. Or the income can also be represented in the form of entries in books of accounts. So if the income is represented in any of these categories, or also in case of such cases, if any of these are satisfied, then he can go from 3 years to 10 years now. Okay. Then there are other amendments where the 50 lakh limit, just to ensure that you are they're not committed to 50 lakhs per year. Other amendments have also been made in the provision. And finally, the word flagged. So if you remember, I said that any income information flagged under the risk-based assessment procedure or risk-based system of the department. So that word flagged has been removed. They have cited that as an inadvertent error in the earlier law. Now, what does all these changes mean? I mean, these are very significant changes in our mind. It significantly increases the scope of the entire reassessment process. So while the finance minister last year said that she wants to reduce this and give more certainty to taxpayers, but there is a worry that these new procedures may actually expand the scope. Whereas earlier reassessments would happen for 6 years, now it actually may have gone, instead of going to 3, it may have gone to 10 because of these expansion. So as I said, source of information has been widened, and therefore he can rely on any of those sources to reopen assessments. Any audit objection, even if it is not final, so even a draft audit objection can be used as a language in the act, so that possibly is an interpretation. Then any court order, again, the language is very wide. It can be any court order anywhere in the country. It doesn't even need to be an income tax court order. It can be any other law which can be used again to reopen. And then the cases, the additional categories that they've introduced, right? If you think about it, income represented in the form of an entry in a book of accounts. So if the tax officer finds any entry in anyone's books of accounts, that's enough to reopen. And I mean, it is quite obvious that if there is any income which he wants to tax, the whole thing would start with some entry, something somewhere, or even the second category of income represented in the form of expenditure. That also, obviously, if income has been earned, it would have been expended in some way. So I think they seem to be now covering any situation in which an income could have been dealt with. And in any of those situations, it can go from 3 to 10 years.
The law, at least the way it is proposed.
Sorry, there is some background.
Or poses a restriction on set off of any loss that you would have.
Thank you. And then the last one is on this, 50 lakhs per year. So as I said earlier, they have made amendments to say the 50 lakhs needn't be per year. So what they are saying is the expenditure, for example, what they found out, or the asset that they found out, as long as that expenditure or the asset is more than 50 years, even if it is over multiple years, as long as the aggregate is 50 lakhs, this condition is satisfied. So even the threshold seems to have diluted significantly, and hence the scope of the entire reassessment is very wide. So that's the first amendment and the expansionary nature of the amendment. Then the other category is just simplification. So earlier there were certain approvals that were required to be taken under the new procedure that was introduced last year. So under the existing provision, first within 148 itself, there was an approval required to issue the notice under 148. Now the other one was to actually decide whether to issue a notice. As I mentioned earlier, there was a procedure to undertake an inquiry by the AO. So to undertake that inquiry also, there was a internal approval that was required. So what they've done is they've simplified that, and they're saying as long as an approval was taken to initiate the inquiry under 148, you don't need another approval to be taken. So within the department, multiple approvals has been removed. So that's the amendment under 148A, 148, sorry. Then, this entire thing So on 133A5, the reference. So what is 133A? It empowers the income tax authority to make any inquiry on any expenditure incurred on any ceremony or event useful for any proceeding. So as I was mentioning earlier, if the AO wants to initiate 148, then he needs to have certain information. And there were categories of information that had been included. And one of them was information under search. So if any search was initiated, that information could be used by the AO to reopen assessments. But it seems inadvertently or whatever that 133A was excluded from that. So now they are saying that even information from an inquiry under 133A will be included within the list of information which can be used to initiate assessment under 148. So therefore, in summary, any inquiry in respect of an inquiry of the expenditure incurred in any ceremony or event as above, the AO shall now be deemed to have information which suggests that income chargeable to tax has escaped assessment. Then the other one is, this rectification of draft. These are drafting errors which seem to have crept in. Mainly, it is aligning the provisions. So, because earlier the search provisions were assessed under the block assessment under 153 provisions, and then reassessment was separate under 147, 148. Last year, search related assessment also was included in the reassessment procedures under 147, 148, 149. So there are just some alignment that has happened to that effect. So under this first amendment is on explanation 2 to section 148. So here cases where search survey proceedings are initiated, AO is deemed to, as I mentioned earlier, is deemed to have information which suggests income has escaped assessment. So what the provision, when they introduced it, they said that if such information is available, then notice can be issued for 3 assessment years related to the previous year. Now that reference to 3 years has been removed, and therefore it seems now that the AO can initiate reassessment for any number of years. So they widened this scope. The next one is again proviso to section 149. So the existing provision is, it said no notice under 148 can be issued for relevant assessment year before April 1, 2021. So this is the whole controversy which I said earlier, that if you are after April 1, 2021, then the new procedure has to be followed. And the new procedure had the 3-year and 10-year time limit. And what the provision was that if, let's say, you are in 2021-22, and under the earlier provisions of 148, the tax office could not reassess you because you were beyond 6 years. They said that the tax office cannot use the new provisions to now assess you. So it was a kind of a saving that was provided, that if you could not be assessed under the old law, you cannot be assessed under the new law. But it did not have references to block assessment. So now they've simply brought in the relevant references to block assessment also here. So if you could not be assessed earlier under 153A or 153C, then you can't be assessed under the new 149 or 148. So that's the amendment, just aligning because block assessments, as I said, has been now included here. Then 153B again is for time limit for completion of search. So they have again done this alignment. So instead of the 153B is no longer relevant because assessments will happen under 147, 148, 149. So they have kind of given a sunset 153B. This one will not apply after April 1, 2021. So just very, very ministerial changes. So nothing substantive in this as well. Then again, continuing with the theme of aligning it with search assessments. So 132.8, there was some prior approval of the prescribed authority to retain seized books of accounts, etc. And there was a period which was linked to the passing of order under 153A or 158BC, which is the block assessment provisions. Now, obviously, since no assessments will happen under those provisions, they've just brought in the reassessment or assessment provision under 143 or 147. Again, continuing with that theme, a bunch of amendments relatable to this theme have been introduced. So 132, there are amendments in 132B, which again, basically the references which were earlier there to 153A, which was the block assessment provision, they have been now amended to make it make the referencing to the assessment or reassessment provisions because of the changes last year, as I mentioned. Okay. Again, sorry that this theme continues. So 133A, which is again relatable to the whole search process. There were certain, authorities that were authorized to give consent for these, searches. So that authority they've changed, and they have given powers to the board to specify what the authority will be to give those consents. It seems that the board can consider availability of manpower. Based on that, they will be authorizing various authorities to give these consents or approvals. So that's the amendment in this one. So again, the same theme is continuing, as I said. The previous Finance Act had amended the procedure for assessment. We spoke about that. So it spoke about certain 153D related approvals. Again, so now what has happened is that, so basically block assessment had certain checks and balances within those provisions that before passing a final assessment related to a search, there were additional approvals ought to be taken because they wanted to keep the threshold high. This was not there in the new 147, 148, 149. So they have brought in that approval process again in 147, that if the reassessment is done pursuant to a search, then this additional approval will also be required. Then similarly, I think, we can continue to cover these, but basically they're all aligning the, block assessment provisions with the existing provisions. So whatever were the time limits under the block provisions have been brought in within the reassessment provisions under these sections. Then the last category is certain clarifications because there were some inconsistencies. The existing provision under 148A provides the procedure to be followed for the inquiry to be made by the AO. But this procedure is not required where a search is initiated, right? So under search, it's an automatic deeming that he can initiate the reassessment provisions. So this one, they have again said that if information is collected under the faceless collection of information, it shall be excluded from the procedure of 148. So this is the similar thing which we spoke about earlier. So, in summary, I would say that the biggest thing that has happened is the expansion of the scope of 147, 148. And then there are a bunch of consequential amendments and drafting errors that have been remedied. So that pretty much, I think, covers everything. We do need to keep a close eye on how the tax office now starts using the new provisions under 147, 148, and whether, as we worry, will the 6-year time limit now get extended to 10 in most cases, which is, as I said, contrary to how the finance minister wanted this, but we'll wait and watch. That's an area to be closely looked at. Thank you. That's all I had. Happy to take any questions.
Thank you, sir. Just a few of them. First one is, what will be the impact of relaxation in requirement to obtain approval for Section 148 notices?
I don't think there's a substantive impact of that. It was just notices at multiple levels that were being taken. So, anyway, if they've taken an approval initially, then they can pretty much run the procedure. So I don't really see much impact of that.
Okay. Another one is various court rulings suggest that a case cannot be reopened based on the comments of the third party like audit or some other assessing officer. So what will be the impact of making audit objections as information suggesting that the income chargeable to tax has escaped assessment?
So clearly the new provisions now override all the old court rulings. So this whole thing actually started with this whole GK and drive shaft, the Supreme Court. Now clearly none of that is applicable because a completely new law has been introduced.
Okay. Okay. Great, sir. Thanks for an helpful session, I'd say. Good time to have you on here also.
Thank you. Thank you very much.
Thank you.